Hey everybody, Todd Vandermeide back for another edition of Freedom Steel. Looks a little different. So, had some problems with a hard drive failure on my computer. So, it is in the shop, and let me tell you what the week has been like. So, out at the club Monday and Tuesday, dealing with a whole bunch of grindings and putting in several parking lots. Tuesday at noon, take off for St. Louis to look at, or to go down for the court hearing. Get down there, meet up with our attorneys, go have dinner, talk over a bunch of stuff. Wednesday morning, more trial prep, and we go through the hearing, 3.5 hours of a hearing, run back up north towards home because I had signed up for a class with Shrek, John McPhee, also known as the Sheriff of Baghdad, on his heavy carbine class. We're going to be shooting out the 600. Great class. And so that I got home about 9 o'clock Wednesday. Ended up class for the last couple of days. It is now Saturday. So, Thursday class. Board meeting with the club Thursday night. Class Friday. Class ended yesterday. And I'm without a computer. So things are going to be looking different for the next week or so until they can get it all diagnosed. There may have been a bug in there, but anyways, that's my life. So you're going to be seeing things look a little different for the next week. But what happened? So we went down there, had oral arguments. Judge McGlynn came out, very great. Kind of gave us a rundown with all the attorneys. The Attorney General's office had 3 lawyers there. The one arguing was Christopher Wells. We had a battery of attorneys there. You had Erin Murphy and her local counsel, Andrew from Clement Murphy. You had Chuck Michelle for our case with the that we're involved in with the FFLs. Thomas Mag was there for his case. David Siegel was there for the SAF case. And the neat thing was the McHenry County State's Attorney sent their litigator down. Name's Troy. Nice guy. They were sued by ISRA and SAF in this, and they sided with us. They're a defendant in the case, and they sided with our side of the case, saying that, no, we think the injunction should be granted, and here's why. And Troy made some very saleable and good arguments. Both sides got what was supposed to be an hour. It went longer than that, obviously. The judge did our side for an hour, and he said he would not delete the time he was asking questions from the from our time. And so and then we would sit there and take a break for 5-10 minutes, come back in, do the other side, all that kind of stuff. So let's go through some of the arguments. I'm trying to keep this video down to 15 minutes or less. Our side made some pointed arguments and focused on New York and Heller and the law, and the judge had questions. And it's interesting when the judge understands and brought out, this is the kind of the small things that struck me. He brought out about, we taught, there's always a discussion about military firearms. And the judge said, but what about 5.90 shotguns? What about 9mm pistols or even 40 pistols? And so you look at that, like, wait a minute. How many people actually pay attention and understand that the Mossberg 590 A, or whatever you want to call it, shotgun, is used by a couple branches of the military, particularly the Marines, and it's actually a military weapon. Built in the civilian world, adopted by the military. 870. I had an 870 when I was going through MP school when they were doing a bunch of training on stuff. So the 870s even in the military arsenal. But it just struck me that this guy knew the 590, which was the first hint that this guy knew a little bit more about guns. And then he had asked a question about 50s, even though none of the 4 lawsuits directly deal with the 50. And I will tell you that from our perspective, that was done intentionally because we feel that the 50 caliber issue is such an issue. You will have all the arguments about if it is in common use. Is it a modern arm? How do you distinguish, this versus that? What's too big? Should this be something that civilians have? Yada, yada, yada. And all those issues can take up just an enormous amount of words or pages and briefs. And we felt that it was such a specialized issue that it needed to be tackled on its own, if it gets singled out. I don't know that it's going to get singled out. I have a feeling the judge may toss out 1.9 and 1.10 in its entirety. So he asked some questions about that. Mr. Mag stepped up to address that. And he stepped up because there was a question about grenade launchers, which, again, if you get into the minutia on this stuff, it will take you down a rabbit hole. And I'll explain that whole thing in another video. Just I don't want to chew up all the time here. But Mr. Mag got up and pointed, and he caught it. I didn't catch it. But in the state's illustrations of a grenade launcher, they actually showed a company that manufactures a 37 millimeter flare launcher. And Mr. Mag just stood up there. So, Your Honor, it's not a grenade launcher. It is a flare launcher. It is a signaling device. And he called the company out by name, which you can see in the state's photo. And went on and said, it's like a Berry cannon or whatever. It is a signaling device. And the judge and him had a little back and forth about it. He goes, and Mr. Mag goes, they're required by the Coast Guard for most boats to have a signaling device. He goes, you can go to Walmart and buy 12-gauge versions of this flare. This is a 37 millimeter. This is not a grenade launcher that is designed to launch an explosive. Now, there are some ATF rules about what you can and can't do with those things and when it turns into a DD and all that kind of stuff. And then he talked about the 50 cal a little bit. And he said, Revolutionary War, most of the muskets were, a 69 or .69 bore. Revolutionary War. And the judge went on and said, and George Washington carried a 56 caliber. Bing, bing, bing. To quote Four Boxes Diner, the judge here knows that George Washington carried a 56 caliber firearm. Okay, I think he's a bit of a history buff. I think he's done his reading. And this was just one of those cases. So now our side did a decent job. The state comes up, or, McHenry County State's attorney steps in and says, hey, we agree with these guys. He sat at the plaintiff's table, not at the defendant's table, even though McHenry County is a named defendant in this lawsuit. Okay. So then state gets up there, Mr. Wells, and we had gotten word a couple days prior, the state was putting on a PowerPoint because the judge said, if you need any kind of, audiovisual stuff, and I'm like, okay, and our side decided not to do that. And but it was an education about things within here. And so the state had this PowerPoint. First page of the PowerPoint, and I have a copy of it. The first page was a collage of pictures from the Highland Park shooting. And then basically it was their brief in a PowerPoint with graphics. So on one side over here, you have what's going on, what they think the law is. And then there'd be like our arguments on this side, and they would put these big red circles with slashes through them, just as like a visual of whatever. And I don't think they got any points for it. I think it was a lame attempt at something I'm not quite even sure about. So, judge starts asking some questions. Funny note, he mentioned that he's been waiting since September for his carry permit. Here we are in the middle of April. So you're talking this guy's been waiting 6 months to get a carry permit? Hey, another little light went on there. Kind of got into whether or not the state was intentionally slowing things down. And the AG, I don't know anything about that, Your Honor. Another little point. So we go into this, and he says, flash suppressors. And he pulls up the state submission of a flash suppressor on an AR. Now, this is what this is what makes me think he really dove into my declaration, because we had several illustrations of flash suppressors, including a picture that when I get my computer back and I have my editing software, picture of 3 different 1022s with flash suppressors. And obviously that flash suppressor was not going to make it any more dangerous or deadly, but it's a prohibiting feature. And he just was, you know, in the state, well, this means you can hide, and but the judge understood that, hey, wait a minute, but doesn't it help the person from being blinded in their own home or like that after seeing multiple attackers? And then he got into, you know, he had some other relevant, you know, it's like, who gets to decide what guns we get to have? And the state didn't want to answer. And in a very circuitous, long, probably about a 5-minute back and forth, they finally came full circle, and well, the legislature does. It's up to the legislature. They're duly elected. It's a representative government, and they get to decide. That's it. And the judge said, hey, I got this Ring app. I see 4 people standing outside my door. My wife's home. My wife calls me. She's the same thing. She is standing at the gun safe. Do I tell her to grab the shotgun that has 3 rounds, a pistol, or the AR with 30 rounds? What got me there was this guy understands that a hunting shotgun has a plug in it. It only has 3 rounds. Despite what the state says, anybody that keeps a shotgun for hunting usually doesn't pull the plug out. If you go shoot trap or skeet, you throw 1 shell in at a time. If you're shooting sporting clays, you load 2. If you're hunting, you're allowed to have, 2 in the tube, 1 in the pipe. That's it. There are a bunch of nuances of this type that really told me this judge got it. And he had made some statements and wanted to show empathy towards what goes on here. I think he takes his job very seriously. The state, one last point here, the state made an argument about, when things are dangerous, and the state did everything we thought they were going to do. They sat there and tried to use the velocity of a .223 round against the velocity of a muzzle loader to make it dangerous. They tried to show that only 2% of the population own AR-style guns, and therefore they are not in common use, and they're trying to play this dangerous or unusual BS and all this other stuff. And they go through all that. And he goes, well, when things are dangerous, our government takes action, and, they will sit there and they will, baby cribs. When baby cribs became dangerous, they took baby cribs off the market. And the judge but baby cribs aren't in the Bill of Rights. There's something very close to that effect. And that's why I think this guy gets it. So, guys, I'll try to cut up some more videos. It's going to be a different format. You're not going to see some of the intros, slick, and fade-outs and the other things because I don't have a computer to do all that, and I don't know how to do all that from my iPad. So we will stay in touch. But as always, it was a good day for us. I feel very positive about it. Frag out.